Now we'll start the next session, which is a seminar on lawyers' welfare in today's age. I request our esteemed panel of speakers to please come to the dais. Shri Mohan V. Katarki, Shri Rakesh Kumar Khanna, Shri Yaswardhan Singh, Shri Prashant Kumar, Shri Amarjit Singh Chandok, and Mr. Yakesh Anand.
Go back.
The Bar Association of India celebrates Lawyers of India Day on the auspicious occasion of the birthday of Dr. Rajendra Prasad, who was the first President of India, besides heading the Constituent Assembly, and also being a person who had inaugurated the Bar Association of India itself. So today is his birthday. He was also an eminent lawyer, and his services as a lawyer in public-spirited litigations were availed by none other than the father of the nation, Mahatma Gandhi. So anybody who is aware of the indigo matters in Bihar, so it was Mahatma Gandhi who reached out to Dr. Rajendra Prasad and requested him to take the lead as a lawyer and represent the indigo farmers in Bihar. So even in a pre-independent era, it was Dr. Rajendra Prasad who had taken the lead and had given a fearless fight in defending the rights of the indigo farmers. So it is in his memory that the Bar Association of India celebrates the Lawyers of India Day. So on this auspicious occasion, first of all, I would like to extend best wishes and to all of you being lawyers, and would remind all of you to follow the path that Dr. Rajendra Prasad had shown to us, and never be afraid of fighting for a cause which is worth the fight. I think Bar Association of India, since its inception, had also never hesitated to represent for a cause which is important to maintain rule of law in the country, which is evident from the fact that when the NJSA bill came, it was the Bar Association of India which immediately filed a petition in Supreme Court and represented vociferously through senior advocate Mr. Anil B. Diwan, and ultimately we all know the result, that the NJSA was struck down. So similarly, when it comes to the welfare of the lawyers, the Bar Association of India has never hesitated in taking up the issue. In fact, as I am rightly being informed, that the Bar Association of India, when Mr. Arun Jaitley was the Union Law Minister, in fact, held a brainstorming session like this, and that time our president was Mr. Falli Nariman, and it was discussed how to ensure that the lawyers' welfare can be ensured through a proper mechanism. And in fact, then Mr. Falli Nariman requested Mr. P.P. Rao, senior advocate, to come up with a proposal to ensure that the lawyers' welfare is taken care of even during the process of filing. That is how the idea of the welfare stamp, the welfare ticket that we all use and put in our wakalatnamas came up, and the Bar Association proposal was effectively presented to the then Law Minister, Mr. Jaitley, by Mr. Nariman as well as Mr. P.P. Rao, and that is how the welfare, the idea of welfare ticket came up. So it has never hesitated to take the welfare issues of the lawyer forward. That's the reason on an occasion like this, when we are celebrating the Lawyers of India Day, we have amongst us an eminent panel of speakers, those who are going to speak on various aspects, because the time was short, and as Mr. Prashant Kumar had already indicated, there is a event fatigue because we have just come back from having the Law Asia conference in Bangalore. And right now, despite that, we thought it is important to have a seminar on many aspects of lawyering and many aspects of ensuring a lawyer's welfare in today's age. So we have got different topics and we have got eminent persons, those who have contributed to that very topic. That is how the speakers lineup is today. And to begin the session, I would request Mr. Mohan V. Katarki to speak on continuing legal education for lawyers. We also had Mr. Jaideep Gupta, however, due to some personal difficulty, he is not able to join us today. Over to you, Mr. Katarki.
Continuing legal education. In what manner and in what way? It helps the legal profession, public at large, and lawyers in particular. As we know, the legal education in India, before we become lawyers, is more an academic-oriented education. It is not strictly a vocational education as it happens in United Kingdom or in Britain. We have LLBs, and they too have LLB, but they treat LLB as an academic course, and to become thereafter a practicing lawyer, either as barrister or as solicitor, he has to undergo a vocational course, that is bar professional training course for the barrister or solicitor course to become a solicitor. And as I have seen, these two courses intensely train lawyers to become either a barrister or solicitor. The procedural laws are taught extensively. The art of cross-examination is taught, which no school in India teaches. Drafting is hardly taught, but it is taught extensively. Generally, we all used to tease that the barristers who come from England are the barristers only because they attended a couple of dinners. That impression I too carried for long, but that's not so. It's a very, very intensive course. The passing is very limited nowadays. In fact, the minimum passing marks itself is 60, and there is only one retake exam. Therefore, a lot of people who spend money and try for bar at law fail. This is all intended to tell that professional training is very essential to produce a good lawyer who can serve the society in a better manner and keep the rule of law high. When you join the legal profession in India, we come across the real difficulties in applying the law to the cases which we encounter. But we make our own efforts. Having been a part of the chamber of some senior advocate or some advocate who is practicing, we'll try to learn the trade. But that's not sufficient, because the laws keep changing. Reforms come. They have to follow up. And lawyers are required to update themselves and keep in touch with these developments. And how do you do that? When I joined the legal profession way back in 1985, within 2 years, I saw in the Supreme Court notice board, in those days we didn't have the facility of social media, that Bar Council of India is conducting a continuing legal education program at Bangalore on administrative law. Since I happen to come from Karnataka, I thought that my December vacation can be clubbed with that. And that's how I decided to pay some 400 rupees in those days, it was a big amount, and go to Bangalore I would have gone to Bangalore otherwise and participate. But let me tell you, what I learned in 2 days in the Bar Council of India's continuing legal education program was much more than what I learned on administrative law in the law schools. It was an excellent program and which really helped me to re-understand the contours of administrative law in the light of the practice which I have started in the Supreme Court. Because when you start applying the law, you feel you understand the shortcomings of your own learning, and therefore a relearning in the academic sense becomes necessary to systematically put the knowledge into the head. So in that sense, I always felt that what we learned there for 2-3 days was of immense importance. Therefore, there has been a suggestion in India that why don't we make continuing legal education a compulsory program so that lawyers are forced to update themselves and offer better services to the society. But there is an opposition that a compulsory continuing legal education might force some lawyers to get out of the profession because if they are not able to pass the exam. Compulsory legal education is not necessarily an exam oriented. In the United States of America, where it is being practiced in some states, not all, it is only the question of attending the courses and gaining the credits so that at the end of particular period of time, you are able to show that I have attended and gained the credits. So in that sense, you are updated, you are forced to attend, and the attendance brings about an updation in the knowledge which helps in keeping the bar alive. I think that sort of a system should be evolved in India. But if you make a compulsory CLE, the question arises, who will provide the continuing legal education? Where is it available? Universities are not again competent to provide this continuing legal education. To some extent may be true that academic, the background is necessary, but also it is true that it has to be from some professionals who have succeeded in the profession, who can impart it to the junior members of the bar or the beginners who are within the first 10 years at the bar. If this has to be carried out, then the association like Bar Association of India are the ones which have to come forward. The bar associations of the local courts also, they should take up the task of providing continuing legal education to the lawyers by organizing seminars, by organizing workshops, by organizing the courses, a single one-day course on Land Acquisition Act, one-day course on Evidence Act, to just bring the updation of the legal developments to the lawyers. As we little before discussed, the Parliament is likely to take up the criminal law bills, and these bills largely are replication of the laws which they want to repeal. But even then, there will be a lot to be done to educate the lawyers, judges, or even police. We are not concerned with the judges and police, they have their own means to get educated. But as far as the lawyers are concerned, certainly the Bar Association of India should take the lead in educating the lawyers with regard to the new bill, not only that such and such a number in IPC has changed into such and such a thing. There are certain changes in the substantive part of the bill. These changes should be identified and told to the lawyers so that when they advise clients, they serve better. This is how I think so. Apart from this, there are many private institutions which are also coming up these days, providing education, continuing education to the lawyers And two of them, which we all see, probably you may have come across in your emails and all. One, the tax can, which provides an excellent education, continuing education to lawyers in the tax matters. And the second is Law Seco, which is the addictive knowledge, it is called, the company name. And both have done excellent work in introducing short courses on various subjects to train the lawyers who think that they require to update their knowledge and serve better to the clients. I'm sure the Bar Association of India, which has all the infrastructure and men and material, will take a lead in the continuing legal education and persuade the Bar Council of India to make it a compulsory thing, at least for the advocates who practice in the Supreme Court and the High Court to start with, and after some time even to all the advocates down up to the Tehsil level, so that every lawyer whom the public trust for good services is really trustworthy. Thank you. I don't take much of your time.
Thank you, Mr. Katarki. Now may I request Madam Rachna Srivastava, Vice President BI, to kindly share her thoughts.
Mr. Prashant Kumar, President, Vice Bar Association of India. Mr. Chandyokji, President-elect, Bar Association of India. Dr. Ananda Pujari, Vice President, Bar Association of India. The speakers, Mr. Sujit Kumar, Mr. Rakesh Kumar Khanna, Mr. Katarki, the state secretaries present here, members of the Governing Council, young students from various law colleges, ladies and gentlemen. Namaskar. A very warm welcome to you all to this seminar, which you have come in good number, despite this being a lazy Sunday. But I see many young gentlemen, not so young gentlemen. Where are the ladies? Why are there so few in number in this August gathering? It's age of women empowerment. The more ladies should have come here to participate in this lecture, in this seminar. This is the reason we are not organizing. We are planning to organize seminars where we'll engage women lawyers of district courts and district courts in different states. We want ladies to come forward, women lawyers to come forward, take a lead. Recently, our Chief Justice had visited the ladies' bar room, and he said, we see many female lawyers doing very well. I think he was encouraged to say that because young lawyers are really doing well. Young lady lawyers are really doing well. And he said, he gave a very optimistic, futuristic picture. He said, 10 years down the line, I see that there will also be men on the bench. So, ladies, pull up your socks and get going. I want those who are not present to be conveyed that they should have been here more in number than our male counterparts. Men had enough. Now it's time to make way for ladies. The topic today has been very beautifully curated. Lawyers' welfare in today's age. Recently, I was in a seminar where it was, the topic was diverse judiciary produces better justice. There were many speakers, mostly male, and the agreement, most of the speakers were of the view that the merit should not be compromised. Therefore, only merit should be the criteria for appointment of a judge. How do you judge a merit? You see, you think a good lawyer will make a good judge? Not necessary. We have seen many not so good lawyers making a very good judges. We have seen many very good, mediocre lawyers making a very good judges. And some not so very good lawyers, they're not good judges. So, when you give a platform to a lady lawyer, unless she gets a platform to show her merit, how do you judge her merit? It's not that it's only leading lady lawyers should be considered for appointment of judges. Give her a platform. Let her show her worth. Not all good lawyers are good judges. It happens with men also. We are not now decided that we'll go to different districts. Some of who were present in the council's meeting are aware, but I'm sharing with other members, members who are present here. We are planning to go to smaller areas, especially to the POCSO court, where the victims mostly are female or children who are not very comfortable to share their experience with the male counsels. We will go to these places, to smaller districts, district courts, and we'll try to interact with the lady lawyers over there, try to mentor them. We will actually mentor them, and so that they come up in front. I think I will need cooperation from most of you who are practicing also in different states, district courts, or you have any allegiance there. I'll seek your cooperation. And that's also a lawyering. That's also welfare of advocates. Thank you so very much. I will not take much time. Call the next speaker.
Thank you, Rachna ma'am. Now I request our President, Mr. Prashant Kumar, to share his thoughts on two issues. I would request him to speak. On Laws of India Day, some special announcements that he did make during our Governing Council meeting, as well as to speak on information technology, AI and lawyering.
Thank you, Anandita. I had requested her not to repeat me too many times, because apart from events fatigue, I don't want that there should be a fatigue hearing me as well. So friends, let me just add to what Anandita said and what we have been discussing as the role of the bar. And it was best encapsulated by none other than Dr. Rajendra Prasad in his speech while inaugurating the Bar Association of India. We were just discussing in the Governing Council meeting that we should play a lead role in the 3 new legislations on criminal law, which are supposed to be passed during the winter session of the Parliament, and what Bar Association of India can do with it, what role it can play. So this is not a new initiative. This is what was stated by our President, first President of the Republic, Dr. Rajendra Prasad, who was himself a leading lawyer, in his speech at the time of inauguration. He says that now we have more legislation but little litigation pertaining to land. I think it is not bad, but at the same time it adds to the responsibility and to the work both of the lawyer and of the judge, because the old conception that everyone was supposed to be in the know of the law and was to be held responsible for disobeying it because he was supposed to know it, should not hold any longer. Because we are producing legislation on such a mass scale now that it becomes impossible for anyone to keep himself fully acquainted with the trends of the new legislation, and details of it, of course, are out of question. It is therefore necessary all the more for those who are in a position to guide and to advise the ordinary man to keep themselves fully posted, fully up to date with regard to the trends of the law, so that they can give the ordinary man the right type of advice, and their advice should not necessarily be for winning a case, although it is important for a lawyer to win the case. But I think he is not there only for winning a case, he is there principally as an officer of the court to help and assist the court. Winning of a case is only an incidental thing. So friends, that's why with a new vigor, the Bar Association of India wants to carry forward the solemn entreaty made by Dr. Rajendra Prasad at the time of inauguration, that we should, especially the new legislations in criminal law and procedure code which are coming, are going to create a lot of work both for lawyers and judges in terms of, because it will be difficult to apply precedents. The section numbers change. So we need to work out a system in which lawyers, litigants and general public can be assisted. And of course the judiciary, that the least time is wasted in comprehending these new laws, which are in fact rearrangement of most of the old provisions and some additions and subtraction for that. But thus turning the pages and comparing things will take precious judicial time, and also the common man which is fed by Bollywood, Hollywood, this thing, Dafa 302, Tajarate Hind, all that changes. So we are planning to create a key. The Bar Association of India will have working groups and will try to create a key where various sections, how they are there in the new legislation, how they were there in the old legislation, what are the additions, what is the legislative intent behind it, how these were interpreted. So some very short explanatory notes. So we will try to do it as soon as the laws are passed. The Bar Association of India will make working groups and try to start doing rudimentary work. Later on, it can be improved upon, as you know, that legislation is just the first step. Interpretation and application of laws is where the real work lies. So we have to create kind of facilitation material for lawyers, for judges, for common men, so that these pieces of legislation which will bring huge change in the way today we see those laws and understand these provisions is going to take place. So at least the drudgery of matching things, turning pages, comparing this thing, we have to see that is reduced, and the lawyers and judges' work is made much more efficient. So that is one thing. Secondly, Lawyers of India Day has some personal resonance for me, even otherwise, as we celebrated for Dr. Rajendra Prasad. My family was going through tough financial circumstances. So after doing my 12th standard, I chose to work in a publishing house. And my first task was to copy mark a publication, which was none other than the select document and correspondence of Dr. Rajendra Prasad. So I spent my most formative year not in the classrooms, but in the National Archives, taking out all the correspondence, documents, his views, notes of Dr. Rajendra Prasad, before the Constituent Assembly, during the Constituent Assembly, and later on his work as a president. It is published in more than 60 volumes. And I think that is what led me to join law, to work in the legal field. So my mental imprint of the rule of law, the basic concepts and how the Republican democracy works, all comes from Dr. Rajendra Prasad and his views and his interactions. Because his manner of working was very dialogic. He had several sounding boards. He never propounded his own views in isolation. For everything he had, other stalwarts, other people he could confide in, to write to them, to demand their views, to validate his own thinking. And it is due to that process that we have the Constitution of India that we have. It is through that process that our first formative years of the Republic itself, with him as a president, could see that how each organ of the state has to play its role with independence, with robustness. So I think when we mark Lawyers of India Day in his memory, we are not only looking at him as a lawyer, as a first president of the Republic, but a person who came from a rural background, was modernist in his views and education, but most of all, the one who could thrive on multiplicity of views, how to absorb them, and how to come with a distilled proposition. And I think this is the core work of a lawyer himself or herself. Without that, you cannot function. So he embodies everything which an ideal lawyer should be and look forward to in his career and professional duties. So with this, artificial intelligence and technology, I don't want to talk too much because, most of us were technology illiterate before the pandemic came and found it more of an irritation or a necessary evil. But then the circumstances during pandemic forced us to embrace technology, to adopt it. And now, even after the pandemic is gone, the system of hybrid hearings and the way the technology is being used in the court processes, justice dispensation processes, continuing legal education, I am in front of very elite audience. I need not go granular in explaining this. All of you are experiencing it and knowing it. So what I want to address myself is on the next step, which people are more mystified than informed. That is about artificial intelligence. And that too when ChatGPT came into play, where a computer program could create literature, could bring together thoughts to have an essay, to have a piece of writing in any subject, whether fiction or factual, that it caught world's imagination. But as a side remark, lawyers were always endowed with artificial intelligence. Because to win their case, to earn money, they could twist the legal arguments in such a convoluted and artificial way, pose needless queries, pose needless and futile propositions of law, which no other person with an ordinary vocation will be able to do. So that part of lawyering, I will say, was artificial intelligence to begin with, because that was not an intelligence which is used constructively to resolve problems, to have resolution of cases which are being presented, but to earn some money and stall the wheels of justice. So now the artificial intelligence, what we talk about, especially in justice sector, is something positive. Something positive if we take it on its face value, not intimidated by it, not mystified by it. So that's what, in very short 2 minutes, I want to deconstruct the artificial intelligence as it relates to our area of practice as professionals. And in this, predictive judgment project was carried out by Ross Computers, and I had personally interacted with the co-founder, Andrew Arruda, who is a Brazilian, in Paris, when we had a special session on artificial intelligence, and I was a co-panelist. So this was in 2017, though it has burst into, public psyche and professional psyche only now. So what is artificial intelligence? We had computing, we had quantum computing, we had, as the capacity of computers to analyze data increased, the speed increased, the usual outcome that you have all the data which the machine will process as per a program and generate outputs. So computing was the base of it. So what is artificial intelligence? Artificial intelligence is a step forward in which a computer program has a basic algorithm, but it is program itself which is able to build further layers of nodes in that algorithm itself on the basis of data which is before itself and which through internet it can harness. So the program can add new parameters. Earlier situation was all parameters were to be built in. They were to be programmed. Now you have a self or sui generis program which with a foundational program can create further parameters, further areas of analysis, and with a very big and powerful computing capacity, do it almost at the same efficiency and speed which a human mind can do. That's why it is called artificial intelligence in common parlance, but machine learning in technical language, where a machine given an initial program can learn by itself. And that is what we do. We get the cases, we get the law, we form our arguments. So that's what an artificial intelligence program does. Now it can lead to various results, because ultimately the capacity is to analyze data. How far in justice sector the analysis of data and adding more parameters can result in adding not just of analytical capacity but also biases. Whether the machine learning algorithm is also capable of de-biasing the data which is there. And the next thing, the intuitiveness of human mind, whether it can replicate the intuitive or subconscious nature of human mind. Because sometimes you just sleep with a case and in the morning you have a new argument. You have not struggled to make it. When you wake up, you have it. So all these things, when you say that it can come with the similar or better outcomes than a human mind, you are just having one output and you are analyzing it. But all these gray areas, where how the subconscious works, how the intuitiveness works, whether a particular program or machine learning algorithm is able to de-bias. I don't say that human mind or the human judges and lawyers don't have predilections or biases of their own. But we become better human beings, better lawyers, better judges by trying to see that how these biases we are able to rule out to do justice. So as a tool, artificial intelligence is very helpful, but then it remains at the level of the tool. Your moral soundness, your integrity, your subconscious, your intuitiveness, your individual personality, and your training to yourself how to rule out biases are some things which you have to continue to cultivate in yourself to be a good lawyer, to a good professional. And no artificial intelligence, at least as I see it, can replace it. Thank you very much.
Thank you, Prashant sir. Now we have with us Senior Advocate Mr. Rakesh Kumar Khanna. His contribution towards implementing the Delhi government's Lawyers Welfare Scheme is well known to all of you. He has always been a friend of BAI. I request Mr. Khanna to kindly give his declaration.
Mr. Prashant Kumar, President, Bar Association of India. Mr. Amarjit Singh Chandyok, President-elect, Bar Association of India. Rachna Shrivastava, Vice President, Bar Association of India. Anandita Pujari ji, Vice President, Bar Association of India. Mr. Sujit Kumar, Member of Parliament. Mr. Mohan V. Karthike, Senior Advocate. Mr. Yakesh Anand, Vice President of Bar Association of India. Mr. Yashwardhan Singh, Advocate, Supreme Court of India. My brother and sister colleagues, and my dear students. We all belong to a noble profession, which is one of the oldest three clerigious professions, as we know in the ancient times. Other two being medicine and clergy. Over the time, the profession has reached the common man, and many of our colleagues on the countryside and even in metropolitan cities join the profession as first-timers in their families. As Rachna ji said, many of our colleagues do well. Maybe many of us sitting in this hall are fortunate enough. But many of our colleagues may not be doing that well financially. That when I contested for Supreme Court Bar election in 2011, I happened to visit most of the district courts in Delhi. And thereafter I also happened to visit many of the district courts, taluka courts all along the country. It is at that stage I realized that many of our colleagues require a good welfare scheme. I did study the subject at that time. There, I must compliment Bar Association of India for taking its initiative in getting the Advocates Welfare Fund Act 2001 enacted. But when I analyzed this act, I found it was too ineffective and too much less for the requirement. I was shocked to see what we are getting under the act was, on payment of the 10 rupee stamp on each wakalatnama, a lawyer will get at the rate of 1,000 rupees per year of his practice in the event of the death. It was a paltry sum according to me, and not taking care of any one of us. It is at that stage I thought of and proposed amendment in the Advocates Welfare Fund Act 2001. I wrote to the then government. I spoke to the then law minister, Mr. Salman Khurshid. He started working on. Let me give you what I proposed. I proposed in my scheme that there should be 3 social securities which a lawyer requires. One is the life insurance, or in the event of his meeting an accident, he should be taken care of. And during that period when he is not able to attend the court, he should be given some benefit. Second, I thought was the medical aid which lawyer and his family require. And last but not the least, I thought of to give total social security, there should be pension if we can link with the profession. Working on these 3 requirements of the social security, I proposed at that time that we as a lawyer, as of day, when we are paying 10 rupees court fee as welfare fund fees, this can be increased, say to 100 rupees or 200 rupees. Actuaries in the government can work out that, and we can contribute 1/3 towards as a lawyer's contribution. Similar contribution can come from the state governments, and 1/3 can come from the central government. With this fund, every lawyer can be provided. At that time, my calculation was around 10 lakhs of life insurance, 5 lakh of Mediclaim policy, and this life insurance premium can be linked to the pension, so that at a particular age, say 65 or 70 years, if the lawyer wants to quit the profession, he shall start getting a pension sufficient enough to look after him and his family, or in the event of his death, his family should get some pension along with the life insurance benefits. I had been taking up this matter from 2011. I distinctly recollect on 26th of November 2012, Law Minister announced on the Law Day that they are accepting this proposal. But unfortunately, as they were working, the government changed. 2019, when I was elected as the President of the Supreme Court Bar Association, and I happened to meet the Chief Minister of Delhi on 28th of December, I remember. 12th of December, I took office. 28th of December, I met the Chief Minister and I talked to him about this scheme. I must compliment the Chief Minister. In the very first sitting and in the very first briefing I gave him, he said, Mr. Khanna, I am ready to implement this scheme. You just send me your scheme, I'll implement it. And he asked me, please collect the data. How much your 1/3 will come to, so that I will give the equal amount immediately. I worked with the Delhi High Court, and I came to know that the total filing at that point of time was around 16,000 all over Delhi, in all district courts plus High Court. On 1st of February 2019, I received a call from the office of the Chief Minister that they want a note. Today is the budget meeting, and Chief Minister wants allocation of funds for the scheme. I sent him a note indicating that lawyers' contribution at the rate of rupees 100 will come to around 16.5 crores. I have that letter which was sent by me, which was sent back to me with the Chief Minister's noting by hand that the amount, similar amount is allocated in the budget. That day, 16.5 crore was sanctioned by the Delhi government. Later, Mr. Chandok and many of the bar leaders, we took up the matter, and this one-third was given up, and total 50 crore was allocated by the Delhi government for this scheme. That very year, in the month of October, November, a committee was constituted, and we gave suggestions in which we suggested 10 lakh life insurance, 5 lakh life medical claim policy, e-library, and catches in all the courts. This scheme was implemented, and in the very first year, the beneficiaries in Delhi were almost 24,000. 24,000 lawyers got enrolled in this scheme, where no premium and no contribution of the lawyer was to be given. It was all free to be borne by the Delhi government. But there was a catch in this scheme. Catch in the scheme was, I, as a chairman of the committee, I recommended that the beneficiary lawyers will be those who are voters in any of the Bar Association of India. My effort was that the actual practicing lawyers should get the benefit. But smartly, the bureaucracy and the politicians removed the word member of the Bar Association. They made it voter of Delhi. So today, the condition is that you should be a voter in Delhi and you should be member of the Bar Council of Delhi. So large number of our colleagues, especially in the Supreme Court as well as in the High Court, who are living in areas like Noida and Gurgaon, Sonipat, Faridabad, but who are actually practicing in Delhi, are left out. The matter was taken up. Mr. Chandok led all of us. I also happened to argue that matter on behalf of the Bar Council of Delhi. Primarily, the argument was that under the Advocates Act and the Bar Council rules, it is your predominant place of practice where you have to get registered as a counsel, as an advocate. We are fortunate that the learned single judge, Justice Pratibha M. Singh, accepted our arguments and allowed the writ petition and gave the benefit to all those who are enrolled with the Bar Council of Delhi, the benefit of this scheme. But the matter was taken up to the division bench and still pending there. So now the issue, according to me, I was just discussing with Sujit ji also, they have, I remember in 2019, in Odisha there is an annual meeting of all the advocates of all the Bar Association of Odisha in Bhubaneswar. I remember that year we released a book written by Anandita at Bhubaneswar. Justice Deepak Mishra was also there, and I raised this issue there also. And I am happy to know that Sujit ji, with his effort, has been able to get implemented this health insurance and life insurance scheme even in Odisha. My concern today is the third aspect of my social security, which I thought of and which I still feel is very essential, how to link it with pension. I have been in talk with the Delhi government. They have been involving me every year in the renewal of the scheme. I have been talking to the law minister. The amount which we are giving for the annual life insurance can be made into a policy which at the end of the policy period can give pension benefits. I'll request Prashantji and Chandyok Sahab, when he will be taking over as Bar Association of India President, to kindly take up this issue. If we are able to achieve, I believe lawyers will have full social security for their life and after them, if in case of any fatality, their families. The second area of concern even today is, sir, that though we have a life insurance scheme, but this is only at the end of in the event of the death. Let me tell you, during COVID in Delhi, we had paid 176 lawyers' family 10 lakh each. And it came as a great help to all those families. Of course, because of that, the Delhi government did come in trouble because the policy amount was increased from 3,500 to 7,000 by the LIC. But we negotiated and we could get it reduced to 5,000. And in the normal time in the next year, the number of deaths was around 36 only. So I believe the premium will again come down. So the two things which we need still to get introduced in this schemes are, one, the pension linking, and second, according to me, should be in the event of accident also, a lawyer should be given benefit for the period due to accident or due to his not being well. Suppose a lawyer has undergone bypass surgery or knee replacement surgery. In that event, for that period of few months, he should be compensated by the insurance company. What in fact my thinking was, if we can amend our Advocates Welfare Act and bring it in tune with the ESI Act. You see, today, see the predicament. A worker in organized or unorganized sector in India is being looked after and compensated. But we as a professional who are giving revenue to the government in the shape of court fees and etc. are not being looked after. So the second aspect also, I'll request Bar Association of India to take up with the government, and if we can modify our Welfare Act and get these total social security for the lawyers, it will be a great achievement for all the lawyers. This is the scheme which I had and which I have in my mind, and I am sure that the Bar Association will take up this issue. At the end, wishing you all, the lawyers, a very happy Advocates' Day. I must thank Bar Association of India to give me this opportunity to talk to you and share my views about the Lawyers' Welfare Scheme with you. Thank you.
Thank you so much, sir, for sharing your views and also giving us a guide towards the future. Now I call upon our next speaker, Mr. Sujit Kumar, Member of Parliament, as well as our member, EXCO member of Bar Association of India, to speak on protection of lawyers.
Thank you, Anilta ji. Mr. Prasad Kumar, President Bai, Mr. Chandyok, President-elect, distinguished and esteemed colleagues on the dais, off the dais, good afternoon. At the outset, I would like to compliment Bai for organizing this seminar and including the topic of protection of lawyers. Not much is spoken about this topic, unfortunately. I happen to speak on behalf of my party on the Advocate Amendment Bill to 2023 in the Parliament during the monsoon session. And I had vociferously spoken about the need to have an advocate protection bill in this country on the lines of the Prevention of Assault on Doctors Bill, which the government is contemplating. 2 lakh doctors signed a petition, 2 lakh doctors signed a petition and submitted to the government on the need to have a doctor protection bill, and rightly so, because we see instances of doctors being assaulted routinely across the country, and hence this need for a bill to give protection to our doctors. But do we not need a bill to give protection to our lawyers? As citizens of the largest democracy in the world, we swear by our constitution. And if there is one cohort of citizens which does the most on a daily basis to uphold our constitution, it is we, the members of the legal fraternity. And hence, I'm so glad that Bai has included this topic of protection of lawyers in today's seminar. And thank you, Bai, for giving me the opportunity to speak on this. But by the way, I'm an accidental speaker. The distinguished member, Sri Sukumar Parjoshi, Senior Advocate and Vice President of SCBA, who also happens to be my uncle, was supposed to speak on this topic today, but he had to leave for some other engagement, and then he ordered me to step in on his behalf, and I'll read out verbatim his address. But I think much more needs to be done to bring awareness about the need to have this advocate protection legislation in our country. And I think not much is being done. Of course, Bai had taken the lead in I think it was in 2021, right? It was in 2021? Sorry, the Bar Council of India had formulated a draft bill which was submitted to the government, but not much has been discussed or deliberated thereafter. So I'm glad this is being discussed, and it will continue to be discussed. This is my hope. Today, we are deeply concerned about the escalating incidents of violence, threats, and attacks on our fellow advocates. The recent surge in such incidents has created an atmosphere of fear and insecurity within our legal community, challenging the very principles upon which our constitutional democracy is built. As we gather here on the occasion of Lawyers of India Day, it is crucial to reflect upon the core values that our noble profession upholds: the pursuit of justice, the defense of human rights, and the adherence to the rule of law. However, it is disheartening to witness a growing trend where those tasked with upholding these principles become targets of violence, harassment, and intimidation. The recent incidents, including murders and assaults on advocates, particularly in Delhi, not only violate the fundamental rights enshrined in our constitution, but also undermine the very foundation of the rule of law. Advocates, as the custodians of justice, find themselves in a precarious position, facing threats that hinder their ability to practice law independently and securely. The independence of advocates is not just a privilege, it is a sine qua non for the rule of law. Attacks on lawyers, whether personal or institutional, jeopardize their fearless representation in court, their integrity, and their commitment to upholding the principles of justice. The rule of law cannot be sustained, nor justice be properly administered if advocates are unable to act freely, impartially, objectively, and with integrity. It is imperative to recognize that the legal profession's independence. It is imperative to recognize that the legal profession's independence is essential for maintaining respect for fundamental freedoms, human rights, and the rule of law. In many countries around the world, special laws have been enacted to protect lawyers from such attacks. From Russia to the United States, from Egypt to Indonesia, nations have recognized the unique tasks faced by lawyers and have taken steps to ensure their safety and security. It's actually ironical that many countries which are not even democracies have similar legislations. But we claim to be the largest democracy, which we are, of course, and the oldest democracy, in fact, but we don't have a legislation to give protection to our lawyers. Even our neighbor Pakistan has recently passed the Lawyers Welfare and Protection Act 2023 to safeguard the interests of advocates. In Russia, a lawyer, his or her family members and their belongings are protected by the state and the federal law on lawyers' activities and advocatura. Article 296 of the Criminal Code of the Russian Federation provides safeguards for the lawyers and persons participating in the administration of justice. Section 1503 of Title 18 of US codes provide protection to officers of the court, while in Egypt, Article 54 of Law number 17 of 1983 Advocacy Law, and in Indonesia, Article 15 of Law number 18 of 2003 guarantees protection to the legal profession. The Charter of Core Principles of the European Legal Profession 2006 provides as A, the independence of the lawyer and the freedom of the lawyer to pursue the client's case. It says, a lawyer needs to be free politically, economically, and intellectually in pursuing his or her activities of advising and representing the client. This means that the lawyer must be independent of the state and other powerful interests. Recently, the National Assembly of Pakistan also passed the Lawyers Welfare and Protection Act 2023, which I referred to ensure that the advocates can render professional services without fear or external influence for the ultimate cause of the administration of justice and the rule of law. And this is Pakistan. The international community, through various, sometimes we need to learn from our adversaries as well, or less respected adversaries. The international community, through various treaties and declarations, has underscored the importance of protecting the independence of the legal profession. The UN Basic Principles on the Role of Lawyers and other international standards emphasize that lawyers must be able to perform their professional functions without intimidation, hindrance, or harassment. Through the 1990 Basic Principles on the Role of Lawyers and the 1993 Vienna Declaration of Human Rights, the famous 1993 Human Rights Declaration, which were later incorporated by several, which were later supported by several states' resolutions at the UN Human Rights Council and General Assembly, the independence of the legal profession is firmly established as the distinguishing feature of a democratic system. I repeat, the independence of the legal profession is firmly established as the distinguishing feature of a democratic system. Article 16 of the 8th United Nations Congress on the Prevention of Crimes and the Treatment of Offenders, Cuba, says that governments shall ensure that lawyers are able to perform all of their professional functions without intimidation, hindrance, harassment, or improper interference, and are able to travel and to consult with their clients freely both within their own country and abroad, and shall not suffer or be threatened with prosecution or administrative, economic, or other sanctions for any action taken in accordance with recognized professional duties, standards, and ethics. As per the International Convention on Civil and Political Right, harassing legal professionals may lead to infringement of clients' rights, particularly the right to due process, Article 14 of the Covenant. In response to these challenges, BCI, Bar Council of India, formulated a committee of 7 members which drafted the Advocates Protection Bill 2021, aimed at ensuring the security and safety of the advocates and their families. The draft bill includes provisions for advocates' safety, financial aid, and compensation for violation of their rights. However, despite the pressing need for such legislation, the Advocates Protection Bill is still pending enactment. I don't even see any discussion about this, honestly, in the political circle. I have hardly seen any discussion on the Advocates Protection Bill. There is wide discussion and deliberation on the need to have a medical practitioners protection bill, and rightly so. And Section 15 of this draft bill provides for social independence of the advocates by providing financial facilities like financial assistance of a considerable sum to needy advocates, providing insurance and medical facilities to the advocates, and loan facilities at a reasonable rate of interest from banks to ensure proper administration of justice and upholding the rule of law. Mr. Khanna has already elaborately articulated the work he and his team have done on the need to have welfare mechanisms and schemes for the advocates. It is heartening to note that the Rajasthan government has taken a proactive stance by enacting the Rajasthan Advocates Protection Bill 2023, making it the first state in the country to provide legal protection to advocates. We should commend the Rajasthan government actually. We applaud this initiative and urge other states to learn from this experience, implementing similar measures to protect advocates without waiting for further protests. The Karnataka government has placed the Karnataka Prohibition of Violence Against Advocates Bill 2023 before the Legislative Assembly, which is likely to be passed in the next session. Whereas NCT of Delhi has prepared a draft of Delhi Advocates Protection Bill and has invited consultation from stakeholders. The state of UP has formed a 3-member committee to prepare the draft bill, and whereas the Bar Council of Punjab and Haryana and Jharkhand have sent the draft of the bill to respective states for enactment. As we celebrate Lawyers of India Day, let us collectively raise our voice in support of the Advocates Protection Bill. The ultimate goal of administering justice and upholding the rule of law can only be achieved when advocates carry out their professional duties free from intimidation and external influence. To conclude, I will draw the attention of the central government and all the state governments to prioritize the enactment of laws that ensure the protection of advocates. Let us affirm our commitment to principles of justice, rule of law, and secure the independence of the legal profession for the betterment of our democracy and society. And I'll request Mr. Prasad and Mr. Chandiok to hold more seminars and consultations on this critical topic. Thank you.
Thank you, Mr. Sujit Kumar. The next speaker is a young and dynamic lawyer. I now call upon Mr. Yashvardhan Singh to kindly come on dais and speak on Advocates Welfare Fund and its reforms.
Thank you, ma'am. Very good afternoon to one and all present here. And I am asked to speak on the topic of Advocates Welfare Fund and its reforms. We've had a very dynamic and detailed presentation on the Advocates Welfare Funds and its implementation planning in Delhi. And I also wish to bring through my talk a little perspective on young advocates because I think that's important as well. But before that, I just wanted to share with everyone what's my imagination of the Indian advocate. So in 1986, Justice Antonin Scalia of the United States Supreme Court was confirmed by a majority of 98-0 by the US Senate. In 2011, he was asked to come and testify before the US Senate on the role of the judges of the Supreme Court of the US in the US constitutional system. He started by saying that often when he asks young lawyers, advocates and students that what makes America a free country, the obvious response that comes across is the Bill of Rights. He, in his classical style, said, "You are crazy. It's not the Bill of Rights." And according to his understanding, it was the US constitutional structure of having legislature, executive, and judiciary as separate wings of government. When I ask myself that what is the distinctive feature of the Indian legal system, to my mind, the answer is simple. It is the Indian advocate. The Indian advocate is one who gives life and breath to provisions like Article 14, 19, and 21. These are advocates who've conceived doctrines like basic structure, which a regular citizen who's not a lawyer often quotes when thinking about our Constitution and when majoritarian tendencies tend to deflate or deconstruct the idea of the Indian Constitution. Dr. Rajendra Prasad's birth anniversary is today being celebrated Lawyers of India Day. I feel there were Indian advocates who helped conceive this Constitution, and there are Indian advocates who till today help to protect and further the constitutional ideals. So in that sense, the welfare of Indian advocates is most critical because the Indian advocate is most critical to public life in India. Moving on, I happened to study the the Welfare of Advocates Act 2001. And what comes to mind is that this is a very powerful legislation. However, there are some issues that come about with its operation. And I request advocates sitting here to take up the cause of advocates' welfare in a vociferous manner. Because this was done by two of our colleagues in Kerala when there was a 7.5 crore scam that came about from the Advocates Welfare Committee Trust, where monies were misappropriated. And the reason was that since 2007, there was no auditing being done of the committee's fund corpus. And as a result, the accountants were able to siphon off money to the tune of 7.5 crores. A PIL was filed in the Kerala High Court. A CBI inquiry is now being done in this matter. But the legislation, Section 13, Clause 2 of this law, the Advocates Welfare Act 2001, enables one to approach the court systems and seek that an audit is done, because the law mandates that the Welfare Trust Committee's audit should happen every year, so that if the audits are not done since 2007, so much amount of money is not wasted. So we have a good legislation, better implementation, enforcement, and I think more advocacy for advocates' welfare is required. Now, from the young advocates' perspective, I wanted to share what Vidhi Center for Legal Policy gave in its research. It conducted research among 2,800 advocates from 8 high courts in India: Delhi, Allahabad, Bombay, Calcutta, Gujarat, Kerala, Madras, and Patna. And out of the 80% surveyed advocates from the Delhi High Court, it was believed that lawyers in their first 2 years of practice earn between 5,000 to rupees 20,000 per month. 40% of the surveyed advocates in Allahabad, Bombay, Kerala, Madras, and Patna stated that lawyers earn between rupees 2,000 to rupees 5,000 per month during their first 2 years of practice. Now, this is certainly not enough for a decent survival, for the financial dignity of a working professional. So therefore, there have been suggestions, and there were 3 suggestions which came across in terms of the Delhi advocates' welfare, which was life insurance, medical claims, pension, etc. But I think there needs to be a more targeted approach when it comes to young lawyers, because their introduction into the bar and first 2 or 5 years really require some kind of support. And therefore, there was something done. And in this context, we have a very good practice from Kerala, which may be replicated, where they now have a scheme that they provide 5,000 rupees as stipend to young advocates, provided they are into the first 3 years of their practice, they're less than 30 years of age, and their annual income is less than rupees 1 lakh. Now, I think this kind of support is extremely critical for an advocate to start on their practice. But at the same time, I want to remind the young advocates in the hall what Fali Nariman says about stipends. And I quote, he says that the worst enemy of hard work is a fixed monetary reward. There's no incentive when your senior pays you a stipend. Of course, it is necessary for you to survive. So take the stipend, but don't depend on it forever. Because then you're in a position of an employee or an office clerk. You will soon begin to work less, and then at 5 p.m., you will wash your face in the basin and go home, which is not what is an advocate supposed to do. Especially a young advocate should remember that there are no hours of a practicing advocate. So, of course, some kind of stipend is essential for our survival in the initial years, and then we can take off from there. But when I thought about the topic of advocates' welfare, I thought to really broaden the understanding from the Act and take 2 other areas. Because the Act is highly focused on immediate financial incentive to an advocate. But I think the advocate's welfare is also critical when it comes to issues of women, toilets, and proper sanitation facilities. Rachna ma'am just said that where are the women in the house? Perhaps the question we have to ask is, are we designed to have a legal profession where enough women can come into this house? Now, Leela Seth's autobiography, On Balance, the first Chief Justice of the Himachal Pradesh High Court, spoke about toilets and her struggle. So when she was a practicing advocate in the Patna High Court, she recollects that there was no toilet for them, and there was one musty room which had a lot of files and which had a lock and key with a librarian, and there were 2 women practicing, including her, in that High Court, and she had to take that key and go to and use the facility. But not only that, there were flying bats in that room, whom you had to escape by covering your head with the sari, because otherwise they would stick onto your head. Right? And from there on, of course, I understand we've moved a certain distance to today. But even when I was researching for this talk, I spoke to some of my colleagues, and they mentioned to me that, how essential is a sanitary napkin dispensing machine for them. So an advocate who's practicing in the trial courts of Delhi told me that one day when they were at Patiala House Court and got their period, they immediately rushed to the Delhi High Court and the new building there, because that has a sanitary napkin machine. So you put in a coin, you get your napkin, and you get done with it. But that's the question we need to really ask ourselves, that how inclusive are our systems designed for women advocates, and how advocates' welfare conception has to be broadened to these areas as well. Also, the other day, I was at the Supreme Court and had a late lunch, so I was there at around 3 o'clock. And you all know how efficiently we are served in that canteen in the basement between 1 to 2, because all advocates get free and all advocates come in. There's a huge rush for getting chairs, etc. But the day when I landed at 3:30, there were around only 5 or 7 tables taken. And I saw all those people who serve us there standing or sitting in the corners and not sitting on the main tables and eating. And I asked them that there are so many tables vacant, why don't you come onto the main tables and sit and just have food, And they said, because that's not the policy. The policy is we have to either stand and eat. So what I'm trying to project to the audience is that when we conceiving advocates' welfare, we keep broadening and keep asking these questions when we can make our institutions more inclusive. Karnataka, I read, has a practice and rules on advocates' clerks' welfare. And all the registered clerks' welfare also have an organization, and they have certain rules made under the Karnataka Advocates Welfare Act for their betterment. So I think when we're thinking about advocates, we can also go on to think about the advocates' clerks' welfare. Right. So this is my perspective in terms of broadening the legislation. But to young advocates whom I meet in Delhi, and also when I go back to Shimla, tell me another very critical thing, which is that capital cities have very high tariffs when you have to come and rent an accommodation. When we come from, let's say, different states to Delhi, or let us say from different districts of Himachal, when they would come to Shimla, the renting would be very high. And therefore, I suggest, and this can be taken up by the seniors in the esteemed panel, that can we conceive a system where, and of course, the other thing which I faced in Delhi myself was that if you're an advocate, you could not easily get a very good accommodation or be acceptable to the landlord. Right. So something which can be conceived on lines of a working advocate's hostel, maybe 0 to 2 years into your practice, 0 to 5 years into your practice, you can be there. Just to, introduce yourself into the bar, get your friends and family to take you seriously and think that you are an advocate. Those 2 to 5 years which people, okay, yes, this person can be given a case and trusted with a case. Right? So maybe during those years, have something like a working women's hostel or a working men's hostel, and allow in those years some kind of, a renting system where it is subsidized, etc. Now that's a lot of support, and thank you so much for hearing me. But I have one thing to say to all the young advocates, that please do not get disheartened in the practice of law at an early stage, or maybe when we are not getting very many briefs. Because this kind of disheartening experiences or disillusions may not only come to you and me, but also have come to many leading members of the bar. And Mr. Anil Devan, a former president of the BAI, in his junior days, was told by another former president of the Bar Association of India, Mr. C.K. Daftari, and when he was sharing about the fact that it is very difficult to get cases. And I quote what Mr. Daftari said to Mr. Devan when he was a junior then. I quote what Mr. Daftari says. "I'm not given to prayer except on occasions and the vacation was one of them. The Bombay Bar, when I started practice, was full of a galaxy of luminaries: G.D. Envirati, Chimanlal Setalvad, Jamshed Kanga, Bulabai Desai, and Jinnah in the first rank, Motilal Setalvad, and K.M. Munshi only in the second rank. There was hardly a chance for others. But all the English judges and most of the leading members of the bar used to sail for England on the long vacations, which were then almost for 3 months. And that was the time when we young members used to pray. We prayed that the ship sinks, but the damn thing never did, he concluded. And Mr. Daftari told Mr. Diwan that use the vacations time and try and appear before the bench. Thank you, ladies and gentlemen, for a patient hearing.
Thank you, Yash, for giving such a fresh, young perspective to the topic of today's discussion, which is lawyering in today's age. Taking the conversation forward, I take the liberty of sharing some of my thoughts before I request the Doyen of the Bar, Mr. Chandyok, to express his expert views and guide us for the future. The topic given to me is moving towards inclusive bar, and I'm so glad and happy that my young colleague Yash actually started the conversation. I'm glad more so because it is not women anymore who has to speak out clear and loud. In any case, our number is very, very less. In a hall full of about 100 men, there are just 5 or 6 women. I'm very glad that young members, young colleagues, men, they are going to talk about us on our behalf, and they're making it so easy for us, because that makes the bar much more inclusive and the conversation much more easier. In fact, on a day like this, when we are celebrating the Lawyers of India Day, and the initiative has been taken by one of the oldest bar associations of this country, the Bar Association of India. Going back a bit to the history, how the BI came into being was, we were thinking of, the India post-independence was thinking of having a unified bar so that it can have its own voice. The lawyers can come together and speak independent of any past structure that may come into being. That is how BI was formed, and the Law Commission of India recommended to have a lawyers forum which is absolutely independent. And the then Attorney General, the then Chief Justice of India, then came forward and assigned the task to Mr. K.M. Munshi to draft the constitution of BAI, and that is the birth of BAI in 1959. Why I am referring to the history of BAI is that BAI has always taken the lead in expressing views that are independent, that is ahead of its time. And it has also, in its recent meetings, had taken certain decision which is ahead of its time. I am so glad to in fact inform you that recently BI did deliberate on how to make the bar associations more inclusive, because what happens, invariably, the bar associations are registered under certain enactments, and then they get their, they get the stamp or the seal from the bar councils, and that is how they operate. And there are regular elections, mostly it is annual elections, where the bar leaders get elected. But what happens, the entire process of electioneering itself leads to a situation where unless you have the numbers, you are not elected. And to get those numbers, you need to have many other criteria about which we are all quite familiar. So for anybody who is in numerical minority, it sometimes gets difficult to be either elected and let alone being heard. In that kind of a scenario, when we are thinking of having an inclusive bar, it is important that we make these bar associations itself much more inclusive by having more and more women leaders, and take it onward from making it only more, better represented in terms of having more women leaders, to a situation where we also ensure that persons, those who are specially abled, are also represented, and they are represented which is visible, because it is important that we have, for example, in Delhi High Court, I think Mr. Chandok and others, those who have seen Mr. Rungta arguing a case, he is much faster and much more efficient while referring to various law journals. He is absolutely blind. But the way he presents a case and his client is amazing. In fact, one of the matters I remember where he was representing the National Blind Association, and I happened to assist, I was one of the government advocates then, panel advocate for central government. We lost the case, and we were so happy for the first time losing a case against the association demanding certain facilities in and ensuring that the infrastructural needs are met for our differently abled colleagues. I'm happy to share that I don't know how many of you have interacted. We have many differently abled lawyers in our courts, just that we don't make them visible because we just do not provide them the kind of facilities that they require. I'll give you a very small example. About 3 years ago, pre-pandemic, I was doing my own survey of how disabled friendly the Supreme Court building is, and was thinking of why not have an audit. I'm happy recently the Chief Justice had in fact formed a panel of which Justice Bhatt was the chairman, and they did submit a report how to make the Supreme Court building more disabled friendly. But back then, the incident that led to me thinking about all this was while sitting in a litigant's canteen, I realized that there was a person who was on wheelchair. He was not able to access the food that was being given to him in the litigant's canteen, and there was no other person to assist him, or there was no chair or table available to him where he could put his food and eat. That led us to call the then secretary and the then registrar, meet them and ensure that at least in litigants' canteen, and we should have some facility for the disabled litigants, those who are coming here. Then the ramps and other facilities started. We had a person, a litigant, a blind litigant coming to Supreme Court, and it was pathetic to see the lady was struggling to in fact use the washroom because there are no brailles. So with our assistance, with our junior's assistant, we could take the person, the litigant, to the front of a washroom. But inside there are no facilities which the blind litigant can touch and reach up to the washroom and use the facility. It was really difficult to see that kind of pathetic situation. I'm hoping that right now, with the report having been submitted with the Supreme Court committee, a lot of infrastructural changes are happening. At least the litigant public as well as lawyers having special needs, they will be able to use court buildings. And we are talking about Supreme Court. When we go to district courts and other courts, we know there are infrastructural hurdles even to access the courtroom. So we must, at least as Bar Association, take the lead in ensuring that the representative, because as of now, we don't even know, as if it is unseen, our colleagues, our specially abled colleagues, those who are practicing, those who have made a mark, and those who are and we must make the entire legal profession aspirational for them. Recently, we had an instance in Supreme Court where the Chief Justice's court in fact heard a deaf lawyer. There was somebody to explain the entire scenario in sign language. Situations like this, examples like this encourage us to work towards making the bars inclusive. And I think Bar Association of India is definitely going to work towards it and ensure that the bar leadership includes some members of such community, so that more and more persons having special needs are encouraged to practice law. Because as of now, there is an entry barrier. One doesn't know whether one can practice or not, because the books are not available in Braille, because the court corridors are not those conducive for people with special needs. Similar is the situation of another group that I would like to flag, because I'm here only to, we are actually a mirror of the society, the legal profession, the bar associations. There is another community that I would like to bring to your notice too, the transgenders community and the LGBTQI community. These are the two communities that we must make our workspaces more inclusive. We are all lawyers, we know our constitution. We are talking in a scenario where the NALSA judgment is already there. So whether we have made our bar associations or our court buildings more inclusive, that we make them feel comfortable. There was a need when we had, when we came up with the Vishaka guidelines, then the Sexual Harassment Prevention Act came, and thereafter the matter has been taken forward, and more organizations, both private and government, and public sector enterprises are coming up with sexual harassment prevention norms which are more inclusive, where they are not only talking about sexual harassment prevention for lawyer, where a complainant is only a woman, but is also, they are also trying to address the concerns of prevention of sexual harassment so far as the LGBTQIA plus community is concerned. In fact, very recently, one of the advocate who is a gay advocate practicing in Supreme Court wrote a letter to the Chief Justice of India, and on the basis of his letter, the Honorable the Chief Justice in fact asked the GSIC, the committee, the Sexual Harassment Prevention Committee of Supreme Court, of which I happen to be a member, to look into the rules and how can we make the rules more inclusive so that the discrimination, the harassment that is being faced by such community members can also be addressed. So it's time that we also make them a part of the Bar Association and a part of Bar Association leaderships across the country so that they do not feel alienated anymore. They do not feel, because we need to understand them. The last, as I just mentioned, the other community that I wanted to talk about was about the transgender community. Recently, we have also had transgender judges. At least one judge that I know personally is from Guwahati, and many more practicing lawyers in Tamil Nadu, in Kerala, Karnataka. And we know that they exist. It's time for us as Bar Association of India and for all of you as members of this legal fraternity to ensure that our colleagues coming from those fraternities are actually being brought forward and they are made more visible so that we understand them better and we facilitate the process and make the bar associations more inclusive. With that, I conclude, because this is just, my idea was to just flag certain issues so that we can take the conversation forward. Now, I call upon Mr. Amarjit Singh Chandiok, our President-elect, and a doyen of the bar who was elected 4 times by the Delhi High Court Bar Association, to give his thoughts. Share his thoughts.
6 times. It was 6 times.
6 times. I'm sorry, my apologies. He's more popular than I thought.
No, it's not that. Thank you. I been listening this from this morning. All my colleagues on the dais raising issues from continuing education to what Anita has brought us to. I only wanted to share with you all that what she referred at the last, that I was elected, my election was also based on an incident that happened. A 33 years old friend of mine, colleague of mine, who was an AOR at that time, when I was abroad, we lost him untimely. And at that time, one didn't know that the Bar Associations or the Bar Council or the Advocates Act did not provide any compensation. That was actually the basis of my first contest in 1998, and had the privilege to be elected by the bar on issues that what you have raised today. Because a community leader must understand, a leader of the bar or a bar council must understand what is the need of the community. My friend referred to Mr. Ungta, the question arose whether he should be designated as a senior or not. And I went to the Chief Justice of the Delhi High Court and say, could be a better person than him to be designated as senior? And I'm happy that the committee accepted the proposal made by the bar and he was designated as a senior. Coming to your instance, and you have to look at it from privileges that you would like to give, whether it's to a young lawyer or to a senior man, you must go into depth. Every bar association has a duty. I see legislations all through this country. My friend read, there are so many legislations, but there's nobody to implement them. Therefore, I need bar associations and bar council to first implement it. As my friend Mr. Mohan said, continuing education, I remember we had one proposal was made that every 5 years we'll like to renew your license. And there was hue and cry from the bar, we can't do this. The position or a problem is not with respect to the practicing lawyers. The problem is that we amongst ourselves have people who have registered in bar councils but are not practicing. They are doing something else. And on the lighter vein, though I remember an honorable judge when I was probably 2 or 3 years old, I was in a part heard and I wanted to, because that matter was listed at 2:30, so I wanted to mention that matter at 1 o'clock, so that I am already in another part heard, which has already started. I took leave from that court to come. But the learned judge just went away. So I was very upset to say, what is this happening? But he called me at 2:15 and said, at 1:15, don't make a mention to the judge, because his stomach is empty and his bladder is full. Therefore, I am conscious of the fact that I am at 1 o'clock between you and the lunch. I don't want to stay here. But I am only requesting you that I need commitment to the cause. My friend rightly said, you don't have to numbers. But if you see the record of Delhi, for example, see the record of Delhi High Court, for example, you'll find we have manifold increase in our lady membership. In fact, I had to 2 times bring to the notice of the Chief Justice that we need 2 more bar rooms for them. But having said that, I'm requesting my lady friends and my colleagues, please consider, you may have your bathrooms separately. You may also have bar rooms separately, I'm not saying. Sometimes you need that for various reasons. But try and see if you can sit with your male colleagues in the bar room, you may have a different approach to the whole problem. Because this segregation is making this problem also. When you sit with a colleague, whether it's a male or a female, you must learn from him or her. When we came to the bar, we were told after you finish your work, please go to 3-4 courtrooms which has these 3-4 lawyers. And one of them was lady. So the increase was ultimately recognized by none else but the Chief Justice of India, who came from Delhi High Court. Chief Justice Jawahar, may his soul rest in peace. He said, it's the first time that I've seen in a courtroom that lady lawyers were not only seeking passovers, were not only giving a brief to her senior, but were actually arguing the case. And therefore, that is the diction that we need to bring within our friends, whether they are young friends like Yash or lady lawyers. We all need to push them. And in fact, Delhi High Court has a privilege that if a colleague wants a representation or placement, not representation, then a senior is bound to keep at least 2 of them. Therefore, these are the traditions. I don't think I need legislation, certainly. I think my friend Mr. Khanna, point out what was his vision of what we should do as a security to the lawyer is simply, we are still fighting that litigation. And I'm not being able to I ask my question and I can't answer it actually. Why should it be yearly? It should be a permanent situation till the lawyer is in the profession. Why should we renew him? He makes another application, then they point out, last time you had said, my name is Amarjit Singh Chandiok. The spellings were C-H-A and D-H-I-O-K. Today you are saying C-H-D-H-O-K-E. Are you the same person? So everything is lost. If you have verified my particulars, then I should continue to be protected till whatever God takes me away, or I want to quit. Yes, pensionary benefits must come to our aid. In fact, the state bar councils must provide for the youngster. My friend said an excellent proposition that we must bring a working hostels for example. We must do that. It is necessary for us to do so. But please consider one more fact, that if you see the intake in Delhi of our population coming from outside, no working hostel will work. Please see the statistics. And we found that at a given point of time in a year, it must have increased down the line. I have not checked it up after 2015. That we needed at least a working hostel for 4,000 women and 4,000 men, which was not possible. And no government, I'm sure Prashant would know about it, how this land that we're talking about, where we have constructed Bar Association of India, how much work had to go into it to get this allotment. Therefore, we all need to first look at what is our commitment to the cause. The cause is my client, cause is justice to him, and I think there can't be a better institution than the legal profession where we provide this justice to him, with the help, of course, assisting the judge. The target that we have taken today on ourselves must be entrenched into each one of us. If I am a designated senior, I must know, I must give back to the society. I must give back to my profession. What prevents me to have 2, 3, depending upon my capacity, to engage younger lawyers, give them the confidence, allow them to do their work. Of course, that 10 to 5 system doesn't work, I agree with you. It can never happen, because you never know. You might have to work more harder than somebody else. One can't be as brilliant as Anita, but she'll probably take the brief and start doing it. Therefore, we need to bring first thing within the profession to make it inclusive, is to first bring them that what is your responsibility, what is your, how do you will provide justice to people who are coming to you, and then look at it from each other. Why am I looking at my left or right in the corridors of the High Court or the Supreme Court to see here is a boy, here is a child, here is a youngster who needs some help. I remember standing, the High Court, the Supreme Court canteen is very small, so most of the time you have to take a coffee and come out. You're standing at that, looking down at the parking, and I saw 3 youngsters looking at 4 cars and pointing out to each other. And I went up to them and said, look at that wagon R. Start from there, you will reach here, I can assure you. Therefore, I must teach that child who comes with me in the profession, what does this profession mean? I need that bar council to learn from itself what it needs to do for its community, whether it's learning, education. Why make it compulsory? Why not make it obligatory on my part? I must be obligated to do that. Legislation don't work in this country, to my mind. It's my commitment that should become that every 5 years, I must go to undergo these many lessons from seniors, attend these many things. All this will only come if I bring a commitment within myself. My friend said you need numbers for election. I see my own view, what she said, there are other circumstances also. But if I tell you from 98 to 2012, the last election, the situation did not change much. But I need to bring that in. I brought the other circumstances into my bars. I've looked at money today. Why do you need money to be spent on bar association or a bar council's membership? I still have carrying with me 500 people's proxies for bar councils to contest the election. All this must change. If you change this, all that we have discussed today, I can assure you will get over. I want to tell Anita that we brought in rules in the Bar Association, to the High Court, where we said disabled person, not only under the Disability Act, but otherwise disabled, would be given chamber block, chambers on priority. And we succeeded. Therefore, it's the commitment that you must show. If I want to be a leader of the bar, I must show what I need to do there. It won't happen otherwise. Bring any legislation to my mind. Lawyers will oppose it, see it. Take your example, mediation. When Justice Kaju was Chief Justice, he thought mediation was a very thing. He made it in the district court. We all went and ransacked it. Totally. But today, look at Delhi. We have 80 to 90 matters a day. Is it not a proud thing? Lawyers doing themselves. It's being managed by lawyers only because they have the commitment to do so. So what I'm requesting you is, please bring all these legislations. Please bring all these insurance. First, get that within yourself why you are becoming a lawyer. What is your duty towards the profession, to your community, to the court? And that, I think, will end most of the things. Knowing my time limit is limited, I can go on with this each word out of my experience itself, instead of going to give you concluding remarks on everything. Take this instance of Bar Association of India. It says I will go to that district where I want to teach the women lawyers her role to be played in a particular way, mentor her. Now, this is what I need. Bar Association is not today, has a legislation over it to do so. It is its commitment to reach out to that person who will be ultimately beneficiary, would be the person who is going to get justice with the help of this woman lawyer. Therefore, that is the commitment that we need. And Bar Association has taken a lead. It will continue to take the lead. And I don't find any reason why we should be behind. That's the distinctive feature right from Dr. Rajendra Prasad's inauguration. See that down the line, the history of this association is to always lead. Many people have tried to copy us. They brought India into it. They brought other things to it. But have they defeated the cause of Bar Association of India? The answer is no. Therefore, time today has come where you must go out as representatives of Bar Association of India, wherever to whom you connect, to say this is the cause that we need to plead and implement. If we all do that, I find no reason why we should not be able to achieve what we need to achieve through legislation only. Mr. Khanna has done a commendable job. There's no doubt about it. But that commendable job got restricted to 50 crores. So I asked the Chief Minister in one of my informal meetings with him and requested him that how do I bring between Amity and Greater Noida, I have 41 law schools. Now, if there are 41 law schools, each school even give me 5,000 or 3,000, how many members are coming to the bar? If 50 crores is your limit, then how do I feed him? How do I look after him to a youngster? He said, no, we had statistics. I said, the statistics has to change every year. You can't keep the same. And if in budgetary proposals you keep changing every year, why can't you budgetary proposal change in this also? So please keep an impact of a particular year, take that figures from the Bar Council of India and probably do it. Now the Advocates Act provide that my place of practice is important, while they say vote is important. So there is a fallacy in that whole thing. Mr. Khanna was right. Bureaucrat thought, or the politician thought, we should put voter. Because, and in Delhi especially, we have an NCR Act, where Gurgaon, Noida, everything is, Ghaziabad is part of the NCRT, but we are not looking at it. And my friend from Supreme Court must remember, we came in an instance where they said the rules provided that you should be within 10 kilometers of to become an AOR. And I remember I was part of the delegation to the Chief Justice of India who said, Bengali market I won't be able to get, my friend rightly said. Today, Jangpura, New Nizamuddin East, Defense Colony are all lawyers' colonies. Niti Bagh alone is not that. All these colonies. Where will you get that? For that youngster to become an AOR, to comply with it. These are the things that the bar associations must take upon themselves and probably see how we can implement to ensure youngster coming in to get encouragement. But that commitment has to come from seniors like me. We have no commitment. Our only commitment is whether I'll be paid my check or not. And I was very surprised yesterday somebody told me that now it is not pre-lunch and post-lunch. Now it is 1 hour, 2 hours or 3 hours. So I said, we'll come down to 1 minute and 2 minutes then. So this is where I need to change myself. And if we lawyers change ourselves, I can assure you, our community does not need legislation. Yes, it needs contribution from the state to meet those unfortunate incidents that happen. Today, to get a liver transplant, one needs 35 lakhs. How will I provide a youngster? Therefore, we need to see, even COVID effect is even going on till today. Youngsters are getting affected by it, more than the elders even. So I need to evolve a system within myself to ensure I meet all such exigencies that come in the Bar Association's life. Therefore, Bar Association of India has taken upon itself. We'll make Bar Association of India and the legal profession inclusive is one of our resolutions for the day, of Lawyers' Day. We shall also do to campaign for a central act for protection of lawyers. And I want to tell my president that a question arose where I was speaking at doctors that why there is so much of violence between the patient and the doctor. And we found that a lot of things were coming in, which are coming in from the point of view of investors into hospitals. And that's one of the reasons for doing so. We have opened our gates for foreign lawyers to come. We already have foreign lawyers in Delhi. Why do I need an act for doing that? But that's the bit. But we are certainly proposing and resolving today for you to consider and pass the resolution that there should be a central act for protection of lawyers and need to be evolved legislation, and you must involve first the bar associations. And I only request you to please consider all those, especially my dear friend on the dais, the parliamentarian, that in Singapore, for example, every legislation is enacted with one lawyer and one honorable judge. Because he looks at the framework of it. Nobody else looks at that. And therefore, the third is we start targeted programs for capacity building of women lawyers, I mentioned above already to you, and to expand the capacity of the building initiatives of the Bar Association of India to the rural and Musaffil courts. I think that is where the commitment lies. And this resolution itself shows why Bar Association is distinct, why we are distinct, and why all of you are distinct. You are sitting here on a Sunday, despite being a rest day for all of you, and still thinking of what can we do on Lawyers' Day. Be a happy lawyering day, do well. When you look after yourself, look after your left and right. That is what I need. And if I can do that, I think we have actually done what Dr. Rajendra Prasad's birthday should actually be. Thank you very much.
Thank you, Mr. Chando. Now I request our President, Bar Association of India, Mr. Prashant Kumar, to please come here and announce the name of the Lawyers of India Day awardees for 2023.
Thank you, Nandita. This was supposed to be the, after welcome address, the first item, but we moved it down the line. There was a reason about it. You just heard Mr. Chandyok, and to put it in one line, what he has suggested, that young lawyers and lawyers need hand-holding and not necessarily handouts. And this is a message which Bar Association of India can only give, because we are not a court annexed association. So we can help in making policy for the bar at large, for the young lawyers and all, without being concerned about, there will be an yearly election in which we have to fight for votes in a court-annexed environment where you have to give in to various interest groups and all. We look at the overall wholesome direction which legal profession ought to take, and by building capacity and having self-confidence and the strength to guide the public opinion. So friends, it is voluntarism which is the key. We have statutory organizations which are bar councils. We have court-annexed associations. But Bar Association of India is a voluntary association where we contribute our resources, our capacity, our intellect, our labor, our initiatives to build a stronger bar, and through that a stronger rule of law, a stronger democracy, stronger justice system, and ultimately the lawyer to become an agent of change. So that's what we are about, and this is the message the Lawyers of India Day must convey, because we have put lawyers into the center. It is our day, and that is where we have to see how we can do best within our own capacity, within our own zone, within our own reach, how best we can do for ourselves and for the society and for the country. So friends, I moved this because you have heard before me Mr. Chandiok, and I know he is a president-elect. So during his own tenure, he will not be able to award himself. So we must recognize him today. So, as a very popular, robust leader of the bar who has actually done work to bring changes on the ground for lawyers' welfare, for progress of the legal profession, for taking up issues and causes which remained invisible, I think the Bar Association of India owed a duty to award him with the Lawyers of India Day award. Then, since we look at a profession, there are some lawyers from so many regions who practiced in their home states and then came to Delhi. So we must recognize excellence all over. So the second awardee of Lawyers of India Day Award is Mr. C.A. Sundaram, Senior Advocate, who is also a patron member of the Bar Association of India. And from last year, we had started the award to honor a leader of the bar. So in that category, we are awarding Mr. Nitin Thakkar, the president of the Bombay Bar. There are two other awards. One is for legal academic and one for a women lawyer. We had such competing claims and interests that we have not been able to finalize it. So while we reserve these two awards, the other three awards will be awarded in a glittering ceremony while we organize the Rule of Law Convention, the Domestic Rule of Law Convention, which this year would take added significance should the three laws which will bring a fundamental change in the way the courts and lawyers will work, the legislation which is the foundational which are the foundational legislations for the legal system itself. So along that, in that ceremony, we propose to confer these awards so that the audience is broader, the engagement is broader, and we can properly recognize the personalities whom we have taken upon ourselves to this thing. And we are also restricting the number of awards each year to 5, so that their value and significance remains pristine and intact. So friends, I think today I don't want to stand any further between you and the lunch. And we have just last item, I'm taking your permission to announce, is to announce Mr. Yakesh Anand to come and give a vote of thanks. He is our Vice President and one of the longest standing members of Executive Committee of Bar Association.
Thanks, Prashant. It's lunchtime and we're all waiting for it. As a master of ceremony, you are responsible for setting the tone of an event, engaging with the audience and providing relevant information. Similarly, a person nominated to propose a vote of thanks has to bring to closure an event. I, on behalf of Bar Association of India, thank all of you to come on a Sunday morning and be with us. Today's deliberations will help us encourage and use in future events to provide a welfare scheme for the lawyers fraternity. Friends, I am sure you all know, over 50,000 law students are joining the profession every year. There's a larger role of bar associations, not only in high courts, even in district courts. Forget about Supreme Court, where we must accommodate all the students. They're looking for opportunities. They're asking what should we do, whom should we join, how should we start. When I joined the profession in 1979, we had High Court, Delhi High Court, with few chambers, with support of some judges, members of the bar, including Mr. Chandyok. Additional land was sanctioned close to the High Court for lawyers' chambers. Similarly, with the efforts of various office bearers of the Supreme Court Bar Association, land was allotted close to Supreme Court Indian Law Institute for additional chambers. This kind of need is felt all over the country. We need a welfare scheme, not only when somebody is ill or somebody is died. We need during the lifetime of a young lawyer. Even lawyers, sometimes if you fall sick or you are hospitalized, there is no support system or financial support to a lawyer's family, his juniors, his clerical staff. We need to have some kind of mechanism to engage in this. This is one of my suggestions. Without going into anything further, I want to thank all of you, and especially members of the Bar Council and Executive Committee of Bar Association of India, who have come from all over India to be present here. My special thanks to Mr. Prashant Kumar, President Bar Association of India, Mr. Chandyok, President-elect Bar Association of India, Rachna Shrivastava, Anindita Pujari, Mr. Mohan Kartaki, Mr. Rakesh Khanna, and various other lawyers who have come from far off. Thank you. Please join us for lunch outside.